option to say we don't want to hear the reference?
My Lord,
as per the language of Article 186.
As per the language of this article, your Lordship do not. But as per your Lordship's practice and jurisprudence, at times your Lordships have refused to answer a question when your Lordships have found that to be too vague.
And that would not be a refusal to answer the question.
Yes.
That would be inability to answer a question.
Yes.
So you consider the question, you may ask me a question which I don't know. I mean, how many stars are there in the galaxy, for instance? And I'll say, I don't know, but I have answered the question by saying, I don't know. So that's not an, so it's we are obliged to answer a question. We can come to the conclusion and say, we don't know. Okay.
Could we also say that it says that we have to form an opinion on the question? We could say that it's not a question.
My Lord, sorry.
So we could, I mean, it says that report its opinion on the question to the President.
Yes, my Lord.
So the question of law that's posed before us, we have to give an opinion. So one opinion could be that this is not a question of law.
That can be, my Lord. Your Lordship may say it is too vague for us to answer. It is not a question of law.
It would still constitute an opinion.
Your Lordship can, even if your Lordship comes to the conclusion.
But that response would also be an opinion.
That's an opinion.
Yes. And if your Lordship comes to the question,
we have to respond.
That a question is not properly phrased, but the meaning is apparent to your Lordships. Your Lordships can rephrase or reformulate the question.
Which we have done.
Yes.
Okay. As we have to form an advice for the President.
My Lord, this is in the nature of an advisory opinion, but according to your Lordship's jurisprudence and jurisprudence from other courts, this is binding. It virtually stands in the same rank as a judgment of this honorable court. So such an advisory opinion would be binding on all concerned.
On question of law, not on the question of facts.
My Lord, yes. My Lord, in this particular case, the question of fact, which was the execution of the person concerned, is now a question or is now an issue which cannot be reversed by this honorable court, unfortunately. What is before this honorable court is an issue with regard to the jurisprudence of this honorable court and a stigma which is there for all times to come on the reputation of that person, and an issue whether the judgment or the conclusion was fairly reached. And it is...
You have to address on this point also the conviction recorded, appeal was dismissed, review was dismissed, and then this is a question of law that has been posed to us to answer. So in that regard also, whether this can be done, because if it is done, this can be done in every case.
My Lord, if your Lordship approaches it from the constitutional perspective, this possibly cannot be done in any other case. If your Lordship approaches it from the pure perspective of criminal law, it can possibly be done in every other case. So the question is, which is the perspective which your Lordship will use? My Lord, there is no other case, and it is perhaps for this reason that my Lord the Chief Justice issued a direction to summon the actual transcript of one of the interviews of one of the learned judges. This perhaps is a unique case in the jurisprudence from common law jurisdictions, where a judge who was part of the narrowest of majorities has thereafter himself given an interview, much after he has retired, no doubt, where